Ouais, ouais, ouais. Et, well, that's not sure that everything. Because I only know about something.
All right. Sure. Okay. All right. We're still missing a panelist, but she is arriving live from Lagos. But we can definitely start. Thanks all for being here. My name is Alexandre Vagenheim. I'm VP of Global Legal Data at Jus Mundi, and it's my pleasure to welcome you all on behalf of Jus Mundi to our office for this Paris Arbitration event. The title of our event is Striking a Sustainable Deal, Balancing State Responsibility and Investor Rights in Mining. I will very briefly set the stage for the conversation. I will then introduce you to our amazing panelists of today, and then we will kick off this conversation. Allow me just to briefly introduce you for those of you who still don't know Jus Mundi. Oh, perfect. Here we go. What do we do? Well, we do provide access to global legal information worldwide and to professionals. But perhaps the why we do it, it's foremost important, and we do that to power global justice. What do we mean by that? We are, our basically responsibility as a legal tech is to participate in building the global rule by giving access to legal materials and legal professionals worldwide. And the way we do it, of course, as a legal tech company, is through a combination of legal expertise and technology. And as part of our commitment to deliver insight to the industry, we propose each year industry reports. And so on the occasion of the release of the mining arbitration report, we decided to host this event and to be joined by specialists in the field to discuss a little bit of the findings that we have in this report. Just to set the stage, I will briefly say three common things within the mining disputes. Perhaps the first thing that is important to know about mining disputes is first the multiplicity of all the actors and the relationship that there exists in the mining sector. Obviously, at the center of those relationships, you have mining companies having direct relationship with host states, and this is where we have the investment dispute, and this is where we will be focusing our discussion today. But they are by no means the only relationship that they are, and obviously mining operates through joint venture indirectly with the states, and here we have more commercial arbitration on the joint venture operation, joint operation agreement, etc., and other corporate disputes. On the other side of the spectrum, we also have disputes with providers, which are more construction dispute, going more towards commercial arbitration or even domestic litigation. And we also have other type of disputes with mineral purchaser, for example, and this gives rise to offtake agreements. For example, in the mining report, you have a dedicated article about those type of agreements and the disputes arising out of those. And obviously, you also have the impact, the overall impact of a mining company on the local sites, and those give rise to disputes with employees, with other type of stakeholders, which give rise to a number of labor environmental disputes, and we will discuss those very briefly. Perhaps the other second point to mention about the mining industry is that it's a complex. There are a complexity of operation and associated risk. And the third point is probably to say that there are high financial stakes, and so it's very capital intensive. And obviously, the more investment there is, the more disputes. This is the economic landscape of mining arbitration that you can find in the report. Globally, we see a huge rise within the last 2 decades, fluctuating a little bit higher and going down, but overall, it's going up. If we look at the cases that we have, we roughly have 800 cases in mining on Jus Mundi. About 500 are commercial arbitration cases, 300 are investment arbitration cases. You can see the proportion, 56% commercial arbitration, 44 investment. What's interesting here, and I'll wrap up with those, the seat of the arbitration, of course, the usual suspect, London, Paris, Washington, Toronto. But I think what's interesting in that slide is what it doesn't say. What it doesn't say is that we see a number of new seats of arbitration. We see, for example, São Paulo having new cases being heard. We see Lagos, and I can see Funke just connected, and many cases are now in the mining dispute being heard, for example, in various African seats. And I think that really resonates to the keynote speech that we heard yesterday from Yas Bani Fatemi about the diversity of seats. And we can clearly see, at least from the mining perspective, seats and even institution, again, what's interesting here, we see the ICSID, ICC, PCA, but what we don't see on that slide perhaps is that we are seeing new institution being chosen to hear those cases. So, coming to our subject of today, we have, obviously, on one hand, states have a responsibility to manage their natural resources in a way that maximize benefits to their citizen, and on the other hand, we have foreign investors. In the mining industry, they have certain rights under international law, under BITs, which includes protection against discrimination, expropriation, unfair treatment, and they have a right to seek compensation against unfair state action. And here is the question for this panel. How does it take to finding the right balance between state responsibility and foreign investor rights? So to accompany us today, I have an amazing panel. We have live from Lagos, Funke Adekoya, who is a senior advocate of Nigeria. She's an independent arbitrator and litigation consultant. She's a chartered arbitrator of the Chartered Institute of Arbitrators. She appears as counsel, as sole party appointed or chair in major arbitral panel of all the institutions, ICSID, ICC, LCIA. She's a member of the ICSID panel, member of the Singapore International Arbitration Center and the Mauritian Center. She regularly provides expert evidence on Nigerian law. So Funke is our experienced arbitrator on this panel. Next up, we have Diora. Diora is a partner at Dentonsa, New York, and her practice focuses on investor-state arbitration, international commercial arbitration. She has 14 years of experience representing sovereign states, corporate clients in significant international arbitration proceeding, and she has been recognized as future leader in arbitration by Who's Who Legal and one of the American Bar Association on the rise top 40 young lawyer. So you understood, Diora is our rising star on the panel. And we have next William Kirtley, who is our seasoned practitioner. William is a managing partner at Aceris Law. He's a Franco-American, Harvard, Columbian, Sorbonne trained lawyer. international arbitration lawyer with over 2 decades of experience specializing in commercial investment and construction arbitration. He has served as counsel or as arbitrator in over 200 international arbitrations. And I think, and that was what I thought was very interesting, you speak English, French, Spanish, but you also speak Baoulé and Dioula, which are African language from Ivory Coast and Burkina Faso and Mali, where we can find people speaking that language. Last but not least, we have Mark Jones. Mark is an environmental scientist and has over 35 years of experience assisting clients with regulatory environmental issue. Mark has provided expert testimony, reports, declaration in a number of domain. He has applied his work on a global scale and has been responsible for technical direction of large environmental studies on heavy metal, dioxide, hydrocarbons, all involving mine sites, petrochemical facilities throughout the US, South America, Australia, Europe, Middle East. Mark is obviously our expert today. Okay, without further ado, I think to kick our discussion, we're going to start and we're going to separate, we're going to bring you through the whole landscape of mining arbitration. And obviously, one very important part of it is about any ESG disputes. And we are going to go through all those type of issues. And the first issue that we would like to address is really that of the impact of mining company on local communities and indigenous people. Obviously, the mining has the effect of displacement, of loss of livelihoods, sometimes damages to cultural sites. And this is summarized by the concept of a social license to operate. And we found this concept in the UN guiding principle, in the OECD principle. But what does it mean concretely? And I turn to you, Mark. What does it mean? And what does it mean for a mining company to acquire this so-called social license to operate?
When you look at mines, mine sites are huge. They're big. They're very invasive. And right now, we're in the process of looking for a whole new future in mining, which is lithium and rare earth elements, a lot of copper. We're moving away from coal and those other types of things. So, what are the major risks that these mining companies face, and how do they deal with them, and how does it apply back to the social and environmental diligence that they need to undertake? So, if you look at the 10 largest risks for mining companies, just take the top 3. 2 of them are environmental. ESG, environment, social, and governance together. Geopolitics, which wars, crimes, etc. And then climate change. So these issues are intertwined now, and they're rapidly changing in the modern environment. Last several years, the UN just started doing this in the last 5 or 6 years, from 2015 on, essentially, and looking at all of these top ESG issues. And the top one of these ESG issues is water management. Then you have decarbonization, climate change, and green production. So this is just the top 4 issues that are out there right now. And among those issues, they really impact the local environment, the social environment of the area where these mines are being placed. And so the UN's looking at these in a very diverse manner. And of course, water is a primary one now. It's big throughout the world, very big in the United States. We don't have many mines anymore there, so all the mines are moving offshore. And water is one of the biggest issues, where you have clean water. Mines need to be able to produce. They all use water, so there's 2 things. We're looking at water reduction, water replacement, actually 3 things, then clean water. One of the environmental issues that's most important to local environments is clean water. If you damage the clean water, you directly impact the social abilities of that area, those nearby cities, communities, et cetera. So a lot of the mine sites are working in huge amounts of emphasis on this one particular issue, because cleaning water costs a lot of money. And more importantly, it consumes a lot of energy, which is the next topic, which is decarbonization. So a lot of the mine sites now are looking at decarbonization, which moves over to climate change. So decarbonization of these huge machines is a very large process going on right now. There's several cases, studies where it's been very, very effective. They're moving, for example, in Western Australia, they're moving to solar panels and wind farms at a huge, huge rate. Since 2012, there were 4 or 5, and then all of a sudden, there are 5 or 6 major projects going in to just deal with that one issue. So you attack climate change, decarbonization, helping the social network. And in Australia, mining uses 10% of the nation's energy. So it's impactful. Let's see, green production. So again, continuing on with better processes, innovation. The mine sites are now struggling with getting highly trained technical people. They've had a lot of retirements, a lot of delays, infrastructure costs, different things like that that really push them to get well-trained people. Geopolitics. I don't want to go into geopolitics, but one thing is, with the rapidity of information passing around the world, one bad deed by one mine site can be on the front page of a lot of newspapers, and it happens very quickly. It happened in the New York Times the other day with northern Brazil, where not big mine players, but artisanal mine players were impacting local Yanomami communities at a very high rate and a very toxic rate with mercury. They were mining for gold. So these things hit the major newspapers around the world and create a concept of mining, which is still being carried on. So I think one of the key things for mines is to collect their data, like Jus Mundi does, disseminate that data because they have plenty of good data. But we often only see the real tough data, which is really heavily impacted communities, social problems, lack of hospitals, contaminated facilities, and typically sick babies. So that from the environmental standpoint, I think that's one of the things that I've looked at mostly.
Thanks, Mark. If we continue and we keep on digging a little bit on that question of impact that there is, before turning to actually the hard disputes and arbitration, is there anything mining companies can do in the first place before actually going to arbitration, etc., in terms of the impact that they have on local population?
Yeah, a lot of the mines, like I say, the technical people, they need to develop a technical staffing that can help design mines that are productive, environmentally friendly as they can be. So there's a lot of work now with, for example, tailings ponds and problems with tailings ponds. Well, that's a climate change issue. You have too much rain, too much water. So they're coming full circle. But I think the biggest concept is to get that information out there. They have it in their practices, but they need to get it out there. And they need to be accountable for it. And the UN has ways to be accountable for that. So there are 17 principles of sustainable development that they can be using to present to the public.
All right. Well, thank you very much, Mark. Now, turning to actually arbitration, and I'll turn to you, Diora. How are those social issues actually basically relating to the impact that we have on those local communities translating to arbitration?
Thank you, Alexander. Hello, everyone. It is a pleasure to be here. Before we dive into the discussion, I wanted to thank Jus Mundi, and especially you, Alexander, for putting together this excellent and timely event, and also congratulate you on the release of the mining report. I certainly recommend it as a very helpful tool for anyone who does arbitration and mining. So turning to your question, Alexander, concerning the impact of mining industries on local communities, right? How does that translate on to investment arbitration, right? In the past decade, we have seen a growing number of cases before investor-state arbitral tribunals involving this issue. A few examples are demonstrative. I'm going to stop maybe on 2 or 3 because we will be discussing them throughout the course of today's presentation. So one of the cases that I think is worth noting from the start is the 2014 case, the gold reserve versus Venezuela. In that case, it's an interesting case because there Venezuela essentially argued that it had revoked investors' permit due to the impact on indigenous communities and local environment. But tribunal essentially analyzed the case and still found that this was, this did not nullify the responsibility to investor, even though there were conflicting interests. In 2015, we've seen a very famous case, Quibarax versus Bolivia, where the tribunal did not ultimately defer to the state's sovereign right to protect public interest, sort of in contravention to its obligations to investor. Again, there was also an issue concerning the widespread opposition to the project, and we have seen an interesting discussion in that case because it concerned the issues that Mark actually raised, obviously in a different country, but it was interesting to analyze, to see the analysis of the tribunal, that they basically concluded that it did not change the unlawful nature of the expropriation that the tribunal found there. And then, of course, we have seen the case called Bear Creek versus Peru, which is an interesting example of how tribunal took into consideration several social conflicts with local communities and how that ultimately affected the analysis on damages, which we'll discuss later today. But there's certainly been an interesting line of cases that are worth looking into in order to see how that impact on local communities has played out.
When we started to discuss those issues, another points that was raised, and I think that might be interesting, I think, and in the whole transparency debates, one of the points that is often raised is how do you make a real participation of the civil society within the proceedings. And of course, amicus curiae brief are always a solution that is put forward. So how do you, and you have, I know we've discussed that, you have some experience, how do you actually prepare an amicus curiae brief that can be helpful for the civil society to be actually participating in those issues that they felt are being affected by the arbitration ongoing?
Well, I don't think there is a golden rule, but I think we should start by noting that the role of non-disputing party submissions or amicus in the various stages of investment treaty arbitration has certainly been increasing in the last years. To cite one of your Jus Mundi report, to date, there's been 94 petitions to participate in amicus curiae, and they were made in 76 different investment cases, both NAFTA and non-NAFTA cases. And of these, 56 petitions were fully accepted, 4 were partially accepted, and 34 were rejected by the arbitral tribunal. So statistics basically shows that when the tribunal has accepted the participation, they have done it mainly based on certain factors, and the factors that we see if we analyze this petitions is that essentially the petition addressed matters within the scope of the dispute, right? The petitioners had different expertise, so they could bring in different perspective to the arbitral tribunal. The petitioners had significant interest in arbitration. There was a public interest in the subject matter, and that petitioner was independent from the parties, of the arbitration. On the other hand, we have also seen, and this is actually referred to in the Jus Mundi report, that the tribunals rejected petitions if they were outside of the scope, if they were they imposed, for instance, unduly or potentially prejudicial burden on the parties, and they were not really giving in information to the tribunal that was essentially helpful. There was also doubts to the petitioner's independence. This was also an interesting consideration that tribunal made very clear. Statistics also show that persons and entities who have requested arbitral tribunals to participate in amicus include mainly non-governmental organizations. So like 39 out of, I think, 94 petitions were NGOs, and only 5 were made by indigenous communities, to make a point concerning what Mark said. Importantly, I think for an amicus brief, as we've seen from the statistics, to be seriously considered, it should be clear on its face that it presents the tribunal with relevant arguments or data that has not already been brought, to the attention, by the parties.
Okay, so we've heard from Mark that availability of data might be an answer. We've heard from you how tribunals have been taking into account social impact issues. And perhaps maybe and I'll turn to you, William, from the point of the investors, what's the reality on the ground? How do you actually keep going with your operation while you actually have a case and an arbitration heard at the same time?
Yes, and whether an arbitration is initiated will make little difference, of course, when the production phase hasn't even started yet. And you see a number of these mining disputes that arise where permits have been acquired, but you're not actually producing. And in that event, it obviously, there's no issue in exercising your rights if the production can't go forward. Even if it has started, it may not make a difference if the mining project has been ground to a halt. We were involved in a dispute in New Caledonia where the Niketi tribe had essentially blocked all nickel mining operations, and the project had died in any event. So there's no issue exercising your treaty rights then. We were also involved in another one in Swaziland involving iron ore, where also everything had ground to a halt. So once you have a dispute in that event, it really doesn't make a difference. What you can say is that it's not a good idea for investors to take justice into their own hands if they plan to use arbitration to resolve the dispute later. And you can see that from Copper Mesa Corporation versus Ecuador, the award of 2016, where the investor fired shots, threw tear gas and mace against the population, and then started in an attempt to calm the situation, and then started an arbitration in an attempt to obtain compensation. And the tribunal found that it was partially responsible for its own loss, and so diminished the amount of damages and only awarded sunk costs on the basis that there was no realistic possibility of the mining going forward. You also see this in South America, silver versus Bolivia, where when the investor aggravated the social conflict, again, the tribunal stepped in and gave them only sunk costs for lawful expropriation. So it's not a good idea for them to take matters into their own hands in terms of justice. That being said, we have found, I wouldn't say necessarily in investor-state arbitrations, but even in very contentious matters, as long as you remain very technical and dry, it doesn't impact people if you keep it non-emotional, like as I think they sometimes do in the US. They tend to be a bit more emotional in their pleadings. But if it's very technical and dry, I do think that arbitration is possible while the project continues, although it's rare.
All right. Well, thanks for this overview. Funke, maybe I don't know if you want to add anything on this particular topic around the social impact of mining activity before we move on.
Thanks, Alexandra, and apologies for joining late. I think the time changes got me a bit confused, so I thought I still had an hour before joining.
We actually changed hour this week in Paris, so that might be why.
Okay. The only point that I would like to mention at this point is that there are trends in Africa in terms of ESG disputes coming into the mining sector. Areas to watch, East Africa. The East African pipeline has at this point still been whilst I won't say disrupted, it looks as if the time frame is shifting because the local communities are protesting based on climate change issues and all sorts of other environmental issues that are being brought up. And so I think it's an area that will become more and more important in terms of mining disputes on the African continent.
Thank you, Funke. And actually, that's a great transition because we are moving towards more actually the environmental part of those disputes. Obviously, this is a central topic. We cannot do without discussing ESG on pretty much all the industry, and it's obviously mining is a critical sector for the green transition, and there is a tension, obviously, that we're seeing between the limited resources and the scarcity of resources that we're going to see more and more, and the growing demand for actually bringing us through our collective journey towards net zero. And on the other hand, mining in itself is also a very polluting activity. And so we are seeing across all those tensions, obviously, a number of issues raised into investment arbitration. And so perhaps my first very general question to you, Diora, might be, to what extent are we seeing or are we expecting to see more claims or counterclaims based on actually those environmental issues into the mining context?
Thanks, Alexander. I'll try to summarize the trends that I see. Well, obviously, the global trend, global focus on ESG is not particularly new. The implementation in the private sector in various parts of the world has experienced certain resurgence in recent years. We see it locally, that the governments commit to certain international environmental instruments in an effort to curb emissions and protect environment. We see it internationally. There is an increased pressure from global community and international organizations. So ESG issues have certainly come up before arbitral tribunals in various parts of the world. We see it in Africa, as Funke already mentioned, concerning the environmental disputes. We see it in Latin America. We see it in Central Asia. We see it basically in different contexts in different parts of the world. So I think that most frequently, and I welcome everyone's comments, in my opinion, the ESG issues arise as either, if we try to organize the cases, they either arise as part of states' defenses based on various doctrines, including the sovereign power doctrine, or as states' counterclaim, right? So if we first start with states' defenses, we've seen a number of cases where the state has raised those defenses. For example, if we continue with the example of Africa, in the BSGR case versus Guinea, Guinea successfully defended a $5 billion claim over a revocation of mining rights of 2 iron ore deposits on the basis that these rights were obtained through corruption. So it's like G of the ESG governance issue. We have seen in Cortex mining versus Kenya, where Kenya also successfully relied on the investor's failure to comply with environmental requirements prior to granting of a mining license to convince the tribunal to decline jurisdiction. So this is an example of E of the ESG. And we can bring in some other examples, which I think William has already talked about in the example of Copra Mesa. But I think what's interesting is how ESG issues as counterclaims play out. And there are known instances of states bringing counterclaims, even though they remain relatively rare. We certainly see an increase in states' practice of raising environmental claims to demand claimants compensate for alleged harm to the surrounding environment or people. So one common question that we observe if we look at jurisprudence is whether a state is a correct party to assert a counterclaim, particularly counterclaim relating to environmental protection. So, for instance, the tribunal in Chevron v. Ecuador 2, they rejected environmental counterclaims based on that were raised by Ecuador on the basis that the proper parties to bring the claims were the individuals who actually suffered harm as a result of environmental damage. Standing also served as the basis for rejecting states' mining-related counterclaims. Famous case is Tetian versus Pakistan. And in that case, Pakistan asserted counterclaims for breach of investment agreement that was entered into by the province, Balochistan. And the tribunal essentially explained that there was the asymmetry of attribution under the circumstances was quite interesting, because while actions of that province could be attributed to the states pursuant to the ILC, International Law Commission's articles for the purposes of treaty claims, At the same time, claims such attribution does not apply essentially for the non-treaty claims under the domestic law. So interestingly, as a result, the tribunal found that Pakistan lacks standing to invoke breaches. Another important point to add is that commentators frequently observe that investment treaties are inherently one-sided because they exist to guarantee the rights of foreign investors. Tribunals essentially look at this issue, I think, quite closely. The tribunals have awarded monetary damages for counterclaims. There are examples. Of course, the most famous ones are the Burlington versus Ecuador and Perenca versus Ecuador, both of which involved environmental counterclaims. The claimants, they were parties of to the consortium in oil and gas exploration in the Ecuador Amazon region, and they brought claims against Ecuador. So it was interesting to see that Ecuador succeeded in environmental counterclaims based on the investment agreement it executed with those two parties, separately. So it's interesting that there was a way that was found in those circumstances to actually succeed on counterclaims. We, of course, follow the news of the, the case in Guatemala. It still hasn't. We don't know what the answer will be, but there is a claim, the $2 million claim that Guatemala raised against the investor. So I think we're yet to see how this will play out, but counterclaims part is certainly, gaining the momentum, and it's, enough information to analyze and talk about.
Thanks, Diora. I mean, what is interesting in what you're saying is, first of all, I think we're seeing that in pretty much all the regions which are involved in those arbitration. And also the experience that we have from the oil and gas industry that might be also very interesting for the mining disputes. And the next question I'd like to ask you, I think it's very related to the topic and the title of this conference, is how do we strike the right balance? Like, how do you strike the right balance between the state right to regulate in a manner that is sensitive to its environment, and obviously at the same time the concern with the investor, the investment protection under a BIT?
Well, I think it's an excellent question, $1 million question. I mean, I think that it's not a secret that the mining industry is complex. It's multi-layered. On one hand, the state has a responsibility to manage their natural resources in a way that maximizes the benefits. On the other hand, foreign investors in the mining industry have certain rights under international law that states agree to, and that protect their ability to make profits from the investments. So finding the right balance, in my opinion, requires a nuanced and context-based approach, which considers political, economic, social, environmental consideration of the host state. And I don't think that there is, frankly, one size fits all for all the regions of the world, because for all the countries in the world, they're very different. They're different stages of the development, and I think they're also changing market conditions that are happening. So I think obviously there is a goal of having a sustainable, or long-term sustainability in the mining sector. So I think it's a really context-specific.
Right, so a nuanced approach for Diora. Let me turn to you, Mark. You've been involved and you have a lot of knowledge into the regulatory change that is going on at the moment, and many host countries are actually revising their environmental law. And so what is basically the impact of these global environmental regulatory changes?
Sites I've been dealing with, date back to the 90s, and you have new sites. So you have old sites and new sites. And since the 90s, for example, in South America, the regulations have changed on the neighborhood of every 6 to 8 years. They revamp their regulations. And so recently that seems to be accelerated through decrees and resolutions that they come up with in each country. And those become problematic because there's assets exchanging hands for a lot of money. And then when you have different regulatory regimes on historic assets versus current assets, it can end up in court quite quickly. And how to deal with it, because contracts were signed at one date and time, and regulatory changes occurred over the period of time where the assets became used or improved. So it's a really difficult transition for the mining companies to deal with these regulatory changes, how they interact with the local and politics and governance. And the other thing is on a social issue. They can spend more dollars, capital on improving social issues around mine sites.
Thanks, Mark. Funke, I see you've been raising your hands. Please, the floor is yours.
Thanks, Alexandre. I just wanted to respond to something that Diora had said about there's no one size fits all. And to say that, well, from the perspective of Africa, there is a view that perhaps agreeing with something that Diora had already said at the beginning, that a lot of the investment treaties and investment agreements had initially been lopsided. And so the position or the trend that Africa seems to be taking now is to say, well, first of all, there's recently been issued a model African BIT, which African countries have been asked to have a look at and to use as a guide when signing new BITs. There's the African Continental Free Trade Agreement Investment Protocol, which, if it is eventually accepted, there was a meeting in February, but we have not yet heard the results of that meeting. Then that investment protocol will also become the guide for inter-African relationships in terms of investments. And both of those documents equalize the obligations between state and investor, especially in respect of things like natural resources, active industry, labor relations, areas where there have often been conflicts between mining companies and the host state. So from the African perspective, just equalizing the relationship by ensuring that the investors in the mining industries in African countries also have obligations that they live up to will, to some extent, resolve some of the issues that come out of mining disputes. That was just the point I wanted to make.
Well, thank you very much, Funke, and I think that's that also raised the question in the more global context, this question of equalizing the relationship, and we're seeing that ESG issues are addressed in the new generation of treaties, and perhaps how are those issues are being addressed on those new treaties, and are we seeing actually some equalizing of the relationship as Funke is advocating for, at least from the African standpoint?
I think the statistics is quite interesting because over 40 new generation international investment agreements, whether it be bilateral investment treaties, multilateral investment treaties, they include provisions that encourage the adoption of the corporate social responsibility and ESG. The clauses, the additional clauses in those new agreements underline the relationship between the trade, investment, and the responsibility, obligations towards environment. So what we see in the new generation investment treaties is that there is, sometimes explicitly and sometimes perhaps not so explicitly, an ESG-related obligation upon investors. Some new bilateral investment treaties have mandated that investors conduct a full environmental impact assessment for any investment and maintain environmental management system throughout the life of their investments. And that's explicitly provided in the new generation treaty so that investors actually know what to expect. It is unclear currently whether contracting states could bring positive claims or counterclaims against investors on the basis of these new provisions, but we're yet to see. Some commentators say that despite the efforts of some treaty negotiators to make environmental counterclaims expressly available to states, the treaty landscape continues sort of more providing patchwork as opposed to actually solving the issue. I think we're yet to see how this new generation treaties will play out. Interestingly, and I think it's, given that we're in Paris, I think the proposed revisions to the Energy Charter Treaty include an obligation on contracting states to effectively implement the Paris Agreement, including commitment with regards to nationally determined contributions. So this is obviously part of the Paris Agreement goal. So we see that example in the multilateral charter that some countries still remain parties to, or will remain parties to.
When the other question, and I'll turn to you, William, that is perhaps interesting in that context, obviously relate to stabilization clause. We've discussed how change in regulation might affect investor rights, and so do environmental concern and other related change in the domestic legal framework threaten actually those assurances that we find within stabilization clause and other like clauses for investors?
Yep, and as you know, stabilization clauses are the explicit commitments made by a host state to one or more foreign investors intended to protect foreign investors from political risk and adverse legislative regulatory change. And these are required to entice mining companies to come to certain states prior to beginning their operations due to the significant capital outlays, where nothing will be earned for the first 5 or 6, 10 years until the initial investment costs are recouped. What's good about the stabilization clauses, frankly, is that you can subject them to black letter law. You can subject them to English law, for instance, or another law that doesn't have split decisions, such as investment arbitration, where there's a lot of vagueness about what the actual standards are, and a lot depends on the arbitral tribunal that's selected. But stabilization clauses, for the most part, have focused on more on first of all, they focus on the fiscal aspects of the transaction more than the changing of the law and fixing of the law. And the issue is that many host states are afraid of losing, or they're giving up sovereignty, essentially, by saying that their laws are going to remain static and unchanged. What's more interesting are there are fiscal and legal stabilization clauses. There are also freezing clauses and equilibrium clauses. Freezing clauses are clauses that do say, like, look, the law will remain fixed for 5 years, and the previous legal and fiscal regime will continue to apply, so during the payback period of the mining project. Equilibrium clauses do give more rights to the state in terms of regulating, saying that, look, if the economic equilibrium of the mining contract is upset, then we will meet to renegotiate. Now, these are interesting because it's essentially an agreement to agree, which is not permissible under certain laws, such as English law. But if you do have a procedure for renegotiating when something arises, new environmental concerns, this could be used by the mining investor to reopen the contract, to say, look, we're now, what was an interesting project is now loss-making. We need to do something about it because there are environmental changes. The truth is, relatively few of these to date that I've found when we were looking into this have directly involved environmental impacts. Changes to the environmental law. It's more about changes to taxation for the most part, and a lot of it has to do with how the stabilization clauses are individually drafted. Would an environmental impact, would environmental changes fall within the specifically drafted clause? But what is good about these in terms of balancing mining rights and state rights is it's much more certain than investment arbitration, frankly. Just because you do have a fix, especially if you apply an external law that's not being controlled by the host state of investment, because the law can change in that respect. If you're applying a foreign law, you do know more or less what the outcome will be. There's going to be a breach of contract, you do a commercial arbitration, you get damages. And that's it. And we should expect more, and these type of disputes have been going on for a long time, for over 100 years. They've had disputes regarding stabilization clauses that have been individually negotiated, but we should expect more in the future in terms of our environmental claims. So.
Thank you very much, William. Before moving on, we are to the G part of ESG, which is more on the governance side. We have about 30 people online, so just a big welcome to all of you. And feel free also to put questions in the chat box. We will have some time to raise them afterwards, and a big welcome to you. Moving on, and I think perhaps the topical issue when we discussed governance issue is perhaps the allegation of corruption, and we've seen many of those corruption allegations blossoming in investment arbitration treaties since 2006, when the Nixit Tribunal in World Duty Free versus Kenya found that a claimant conduct in procuring an investment contract through bribery was sufficient as a matter of international law and international public policy to render that claim under the contract unsustainable. And since then, we've seen many numbers of allegations, especially in the mining sector. And I'm turning to you, Funke, to give us an overview of how actually allegations of corruption are treated in and how are they raised within the mining arbitration context, at which stage of the arbitration, etc. Please, Funke.
Thanks, Alex. Yes, World Duty Free and Kenya is the most famous case in corruption. The case went to trial, and the evidence of corruption was actually given by the claimants. And so it remains the case of note. But evidence of corruption as a bar to a claim can actually come up as a preliminary point of law, where a party says, usually the respondent, you cannot even listen to this claim at all. Let's not even go into the merits, because there's been corruption. The second in which it comes up is obviously when you have a discussion on the merits, and then the state usually brings it up as a defense on the merits. At the preliminary point, as a jurisdictional point, I think Metaltech and Uzbekistan, I think, is probably the first case in which an Exit tribunal actually said, we're not even going to listen to this case, having listened to the arguments of corruption being brought by both sides, but mainly by the respondent as to how Metaltech actually got its investment in the country. And the tribunal actually said that they had the power to look at it, and they found that corruption existed, and the amount of corruption that existed in the manner in which the contract, the investment was procured, was sufficient to have violated Uzbekistan law. And in that respect, they declined jurisdiction. They said there was no investment established in line with the law. So that's a preliminary issue. Usually though, and especially in mining cases that have come up in Africa, allegations of corruption have come up as a defense on the merits. Although interestingly, in the current case, which is trending, not exactly mining, but still in the extractive industry space, which is PNID and Nigeria, the corruption allegations are being brought up as an effort to set aside an award. So they came up actually after the closing of the proceedings. But as a defense on the merits, I think the most recent case is the Guinea case that Diora had referred to, BSGR, in which Guinea, as a respondent, raised it as a defense on the merits. Basically, the defense was the mining rights were procured by corrupt means, as a result of which the tribunal should either hold that those claims were not admissible at all, or they're totally unfounded even on the merits. The tribunal decided to take it on the merits. The respondent's case laid out 4 elements of corruption, which are basically what most tribunals, most authors see as what are called the red flags of corruption. One was the fact that the investment was procured through a shell company. There was the use and access to high officials of the respondent state through the then president's fourth wife, who acted as the consultant, the go-between. There was then also evidence of influence peddling, also through the same means. And also the respondents said that the claimants had actually tried to procure the silence of a witness and to destroy evidence before the tribunal. And these are what I'd term the red flags of corruption. So in essence, Guinea's defense was that the revocation of the mining rights was based on corruption, and as such, it didn't constitute to be an expropriation. The investment was null and void ab initio. The mining rights were wrongly granted. And this is what the court actually did find. And the court, and there were allegations of corruption on both sides. That was also an interesting thing. There were allegations of corruption. BSGR actually said, oh, the reason why our rights are being expropriated is because the government has changed. And the new government actually wants us to do the needful, or words to that effect, or they want to take away our mining rights and use it to compensate their political allies. But having listened to the case on the court actually found that the respondent had not complied with proper governance principles, had engaged in corruption, and dismissed the claim. So those are the two areas. In many instances, though, the allegations of corruption are brought up as a defense on the merits by the respondent state.
Thank you, Funke. So obstacle to jurisdiction, defense on the merit, and you even mentioned set aside of proceedings to annul an award before national judges. This is something that we obviously have seen very recently in France. You already touched upon the red flags, etc. But what's the standard of proof applied by tribunals to determine corruption allegations?
I think this is an issue that is still unclear. I think all tribunals that have had to comment on issues of corruption have found that it is difficult to prove. And therefore, the good thing is that tribunals are now confronting the issue. At some point, tribunals would refuse to confront the issue. It was a criminal matter, but now they are confronting the issue. The ICSID rules have basically, the tribunals have basically said under the ICSID rules, we do have, I think that's rule 41, we do have the power of our own initiative to examine whether we have jurisdiction. And if these allegations of corruption are being made, then they go to international public policy. And since arbitrators have an obligation to ensure an enforceable award, one of the things that they need to look at is that any award they give, the chances of it being set aside on the grounds of being contrary to public policy are greatly diminished. And so tribunals have then taken it upon themselves, the initiative of looking at corruption allegations. The issue of standard of proof, though, as to whether it is on the balance of probabilities, which is a civil law standard or is civil standard, or it is beyond a reasonable doubt, which is a criminal law standard. Tribunals have taken a position that seems to be somewhat in between. It is not a criminal standard because clearly tribunals have said this is something that is quite difficult to prove. But where there are red flags, then the tribunal will take that into consideration and look at the evidence that the party relying on evidence, or relying on either a defense of corruption has provided. And if we do find these red flags, then the burden will shift to the other side to disprove that those red flags are not red flags as such. And so I would say that the trend today seems to be that the burden of proof is a shifting burden. It has moved away from the burden of being satisfactory. As to what is satisfactory, it now depends. The claimant who's alleging corruption does have the first burden of providing sufficient evidence to enable the tribunal call upon the other side to discharge that burden. So I think that's where we are at the moment.
Thank you, Funke. We've seen how this is handled by tribunal, what's the standard of proof, whether tribunals actually are raising that ex officio or not. I think what can be interesting perhaps is to see how are states actually handling and tackling those issues of corruption. And I turn to you, Mark. Are we seeing, how are states actually tackling the issue of corruption? Do we see increased transparency, obligation upon investor into how they handle the mining operation daily, etc.? What are the measures that actually we're seeing states putting in place to tackle corruptions?
Yep, very good question. I've personally been involved in cases where I was seconded to a lending group as part of a multi-billion-dollar lending program, and that was between a state and multiple major banking and investment groups. And in that case, the environmental portion was World Bank standards. Very straightforward, very upfront. But the contract that I personally signed was 250 pages, and of that, 10% was corruption. So I think you put that in a upfront and in place right away. You know, it was a contract between me and the company. So it was pretty strict on me as an individual, and I find that to be very effective. Worked out well. However, given it 5 or 7 years later after this occurred, I just saw an article about $12 million missing. So what I thought was up front and straightforward might have been a little more complex than I had. You have to watch out for that too. It happens on all levels.
Thank you, Mark. Are we seeing any trends in different regions? William, Funke, you discussed a lot about Africa already, but do we see any other trends in terms of allegation of corruption being dealt in various manner in Latin America, in Australia, US, Canada? Do you have any insight you would like to share, Diora?
Just one thing to add, what Funke already talked about, the metal tech decision versus Uzbekistan. In Central Asia, it's interesting to see how the tribunals are becoming more inclined to consider this issue. I remember working on cases involving Central Asian defending states 13 years ago, and some of the tribunals would not really address the issue or look into the question of how the investment was obtained, what actually was involved in the process. And now to see that there is a deep dive that the tribunals consider making is a really great development.
Thanks, Diora. William?
US, Canada, I mean, obviously, yes, in the US and Canada, corruption has always been severely punished. You know, I know that there's quite a bit of legislation about that that's been going about the world, but I wouldn't say there are any particular developments over the past 5-10 years.
All right. Well, then I think we can move to the last part of this journey onto mining arbitration disputes. And obviously, mining claims are significantly larger than in other industry. And I think we can't really end this panel without discussing a little bit how damages are alleged, are awarded or not awarded to investor. And I turn to you, William, and again, from the investor perspective, what do you see as mining industry specific factors that drive the valuation of damages?
Yes. So, you know, obviously, my first advice would be to get a very good quantum expert if you're involved in an investor-state arbitration involving mining assets. But the truth is that compared to oil and gas exploration, it is easier to value an early-stage oil and gas asset than a mine, which does have implications for quantum. And for oil and gas exploration, they have simpler methods. They have imaging techniques and well testing that can give extensive information about the hydrocarbon reservoir, and it is much harder to predict the geological and physical properties of a mineral deposit without very expensive drilling, testing, and engineering campaign. Certainly putting it outside of the hands of all but the largest corporate entities. And this does have a large impact on early-stage mining projects, typically limiting damages to sunk costs. So even if you're sitting on a gold mine, if you can't prove how much is in the ground, you're going to get the amount you invested, unless you can prove it. what if the investor cannot even get to the assets it owned in an attempt to measure them? Now, this is a real problem. We had an interesting case that's actually ongoing before domestic courts in a Balkan country, where the investor owned a marble quarry, and someone else did a very crude forging of signatures to put the mining quarry rights in his own name, in the other person's name. And so they're fighting it out before local courts, they got bad decisions, they're threatening denial of justice, et cetera, which is a very hard claim to win on. But they can't even get to the mining quarry in an attempt to measure what the value of these assets are. So what they did was they took drones and they flew it above to try to see the blocks that their competitor who had forged the documents were extracting. Now, that's not a very good way of doing it, but certainly if you have social protests and other protests and you can't get to the asset and it's an early stage mine, you're going to have a very, very hard time proving damages. And until you're actually producing, you're going to have a very hard time convincing an arbitral tribunal in order to allow an income-based method to determine the value of what was expropriated or what was harmed. And obviously clients ultimately care about the compensation they're receiving. And so if they find out that they're only going to get the sunk cost and investment that they think is worth billions of dollars, they're going to be very unhappy and may not, they'll have second thoughts about going forward with arbitration. Now, operational stage mining projects can be valued on the income they produce, although there are these issues for early stage projects. And what's interesting, and I think we're going to get to that next, is how tribunals have been taking into account ESG-related issues and damages assessment.
Go ahead.
I'll dive in. And I do think that 20 years ago, ESG would have been largely irrelevant to quantum. And even some modern decisions, such as Kibrex versus Bolivia from 2015, where the granting of an environmental license led to local protests, which ultimately led to the concession being taken away, did not lead the tribunal to diminish damages. The tribunal, as a mining project, was a going concern. The tribunal considered that it was completely appropriate to use a discounted cash flow methodology, an income-based method, to award compensation to the foreign investor. And where it gets interesting is more recently, in 2016, with Copper Mesa Mining Corporation versus Ecuador, where they started focusing on ESG for compensation. And there, the tribunal assessed the claimant's contribution to its own injury. This is the case where the claimant's senior personnel was alleged to have directed violent acts against anti-mining protesters, firing guns and spraying mace at civilians. And they determined this had a 30% impact on damages, at a 30% of damages, and determined that the failure to complete an environmental impact study also warranted a further reduction in compensation. So this is very interesting. They're saying because you didn't do your ESG, you're going to get less money in the end. And in Bear Creek Mining versus Corporation versus Peru, you also saw this. They're no longer simply using a DCF method or sunk cost methodology. But the tribunal determined that although Bear Creek was not at fault in its relations with the local communities, and because its outreach activities to local communities were conducted with Peru's approval, support, and an endorsement, nevertheless, because of the lack of support of communities, this had a direct impact on the tribunal's assessment of whether the project was viable, and hence the compensation awarded. So they said, no, there were too many environmental protests. You wouldn't have made a lot of money in any event. Therefore, we're going to reduce the compensation. And actually, here they determined not to give loss of future project profits and limited it again to the sunk costs. And in that case, arbitrator Philippe Sands, who you might have heard about, did want to go further. And he has a very interesting dissenting opinion where he found that claimant's contribution was significant and material and that its responsibilities were no less of the government. For this reason, I would reduce the measure of damages by 1/2. So it's a fairly arbitrary amount that's being reduced, but you do know that certain tribunals, if you select them, will take into account non-compliance with ESG and the impact that this has on the actual mining operations. And ultimately, tribunals have found two ways to take into account ESG and damages. And it's either to make the investor recover only their sunk costs, which tends to be much lower than income-based methodology, or to diminish damages on the basis of the investor's contribution to it. And we should expect to see more of that in the future.
Thanks, William. Since you started by saying that we should get a very good quantum expert, so I'm going to turn to our expert on the panel and ask you what's actually the role of expert in the valuation of ESG damages and claims.
Quantum in the United States, not in international arbitration, because of the ESG issues, and what happens typically is I get called in to assist the quantum expert with the ESG issues and try to put some kind of bounds about those, and it typically ends up, like William said, 50%, 30%, 25%, sort of arbitrary numbers, which is very interesting because it's difficult for the tribunal to understand the science that goes into saying the gold ends here and it has this much volume. It's going to cost this much to extract it, and that much we'll sell it for at a future price. So it has to do with all those kind of issues that really are difficult to quantify very specifically.
Let me turn to you, Diora. How have tribunals evaluated damage so far? What's the practice? What are we seeing about environmental damages? What successfully works?
Well, I think William covered most of the things concerning the cases. I think one case that we could talk about is the South American silver, and I think that case is interesting just to further points that William already made. There, it was interesting because investor acquired concession, right, the mining concession, and it was the area that was entirely populated by the indigenous community. And during the drilling activities, that there were certain actions by investor that basically wronged several, members of the local community. They polluted sacred sites, and it was well evidenced during the course of the arbitration. So it was interesting because in that particular case, there was a very strong example of communities' pushback, understandably, because they were very outraged and were engaged in protests. So the community essentially made a point, and the government heavily relied on that because there were severe impacts on the environment. And even though there was overwhelming evidence of the investors' non-compliance with any environmental or basic treatments, interestingly, the tribunal, even in light of those horrific examples, the tribunal did find liability in that case. It found that the actions of the state amounted to expropriation. It did award damages of 18.7 million out of around 380 million. So clearly there was an example of how the tribunal took those actions into account in its award of damages, given the violence that occurred.
Thank you. Funke, is there anything you'd like to add on this particular topic, or?
No, nothing really, other than to say that if a mining dispute, and I go back to Quartec and Kenya, if a mining concession has not complied with the relevant environmental legislation in the first place, why should the tribunal accept jurisdiction and then go on and award damages and then perhaps give a discount for failure to comply with environmental regulations? It goes to proportionality, I agree. And possibly there's also a question as to whether those environmental breaches were not legislative breaches as such, but breaches that were perhaps more social or community breaches. But my take would be that tribunals should actually look more carefully and I go back again, Kotek and Kenya, they should actually go back again and say that if you have not complied with the environmental legislation, then do you really have a legitimate investment? That's just my take.
Thank you so much, Funke. That brings us almost to an end. And so I'd like to open to any question that there is, either on the audience or online. If there is any question, we've covered a lot of issues. We went through the E, the S, and the G of ESG, and see how those really operate within the mining dispute field. I don't know if anybody has any question that has been raised, but if you have, or while you prepare, I might have a concluding question for our panelists and in a very brief 30-second answer, how to make it work. How do we strike a sustainable deal, balancing the interest of state and investor right in mining? And I can start with you, Funke. If you have a very quick answer to that you'd like to share with us.
Yeah, my quick answer would be that if investors, and I speak again from the African perspective, where the feeling is that in many instances, investors in the mining and the extractive industry do not comply with the regulations that they would have to comply with at home. And therefore, my quick position would be that to avoid disputes, if investors acted in the best interest of their investment, there would be less dispute.
Well, thank you, Funke, for this wise suggestion. Diora, same question. How do we strike a sustainable deal?
Well, to keep up what I said earlier, obviously it's a balanced, nuanced approach. It has to be context specific in all circumstances. And I think that we are to learn from the cases that are to come.
Thank you, Diora. William?
My advice, draft bespoke stabilization clauses that are very detailed and where both the parties have significant input, which you can't do with everything else, and act in good faith.
Thank you. Mark?
With it, invaders. Come into these communities and involve yourself. And, it's not a whole lot of money, but it's a huge investment.
Thank you very much. No question from the audience? Bart? Yes, please.
So this is building off of Funke's last remark, and I was wondering whether one way of explaining the apparent inconsistency in the way that different tribunals have approached illegality concerning an investment might be whether the illegality goes to the consent to arbitration, or whether it is an element that arises with respect to the merits. So in other words, in a BIT case, many bilateral investment treaties are limited to investments that have been made in accordance with the host state's laws. So if the illegality goes to the making of the investment, then it wouldn't comply with the terms for consent. On the other hand, if it's a contract case, or if the illegality occurs later on in the life of the investment, then it might be more of a matter for the merits. Attempted a unified field theory.
Funke, do you?
Yeah, yes, I do agree with that. In many instances, it does go to the wording of the BIT. If it must be a legal investment, and some tribunals have actually said that an investment must comply with the laws of the country, which is, again, Kotek and Kenya. If it is not that, the point at which the corruption also occurs is also an issue. Because even if the corruption occurred in a means of obtaining the investment, then that obviously goes to international public policy. If the corruption occurs midway after the investment has been acquired, then possibly, yes, as you've said, it is a discussion for argument on the merits.
Thank you, Funke. Any comments rising from there?
Thank you. I think this one's really for Mark, which is why, when you're looking at sort of where companies are environmentally unsound, do you not kind of value the mine as if they'd been produced soundly, as in the extra cost of cleaning it up and sorting it out, rather than taking a kind of a 50% cut?
First off, you have to evaluate what's in the ground. There's various ways to do that. It's 1, 2, or 500 wells. So that's a big investment. The second investment is then looking at the future, because mine site doesn't operate for 4, 5, 6, 7 years, depending on the size. 30-year life expectancy, and then 30 to 50-year recuperation. And that recuperation is remediation or restoration. And the restoration now is often going to 2 hectares per hectare of disturbance, plus other things, right? So biodiversity comes in if you're in the different environments. And out of profits, should they be pulling aside certain amounts of money? Oftentimes, those amounts of money are set aside in the very front end, so before any money's been made, or the total number, right? So that's very difficult. And then insurance that it's there at the end. That's a big thing for communities and states, making sure it's there. And I like what Funke said about operating from the state you were in. You would operate differently in Canada or the United States than you would in, say, Guinea or wherever, South America. So I think that's been a big problem, is that assurance on the backside, because it's a long way out there. I worked on one recently where it was 30-year expectancy, 50-year recuperation. That's 100 years. Right. Right, and it varies onshore and offshore there. And I'm looking at one right now, an oil company that has 5 wells in the Amazonia, exploration wells, along a seismic line. And those wells were, $50 to $80 million a pop. And the issue is over abandonment and what the local clause for abandonment means for a mine site of that value, or for a well site of that value. So keeping the helipad open for access is not abandonment in one view, but the whole site has been abandoned except for that. So that's kind of the regulatory discussion I was having before.
Thank you, Mark. Georgios?
For the very interesting presentations. I have a question regarding to all the panelists regarding the issue of corruption. Should tribunals draw adverse inferences based on the refusal of a party to submit evidence that would help the tribunal determine the existence of corruption, and perhaps shift even the burden of proof to the other party, the refusing party, in its mission to actually determine the existence of corruption? Thank you.
Who would like to take that? Funke?
I'll jump in here and I would say yes.
Straight yes from Funke. Somebody else wants to elaborate on that? Okay. Any other question to our panelists? Jeremy?
There's a question online, Alexander.
Yes.
Okay. So I have heard recently in the news that we opened a new mine in France after more than 30 years, which is a lithium mine, and apparently a green mine, which is producing less than 1% of a traditional mine, but apparently with very little impact on the environment. So I was wondering maybe if an expert can tell me if these kind of mines will become common, and if they will end up killing mining arbitration at a point if there is no more impact on the environment.
Oh, that's a really good question. Of course, lithium mine and rare earth elements is huge focus right now. It's incredible. In fact, some of the mines that may reopen or may open in the United States are lithium mines in Nevada and Arizona and the dry states. Lithium mining requires huge amounts of water. We haven't had any in areas that we've really looked at because most of them are in Mongolia or, China, the Far East, where things are pretty much controlled. So we haven't seen the impact of a lithium mine in the United States directly. But when you look at these mines, Bolivia comes to mind, High Altiplano, where you have super large salt flats. So you're talking about removing huge quantities and creating brine solutions to extract the lithium and the rare earth elements. So it's yet to be tested. And if it's truly green, that's better, because a lot of those types of mines are located in high solar areas, and the Bolivian mines will use extensive solar energy. The plans are right now, but they haven't been implemented. So I don't know the ultimate answer to that question. Sorry.
Any more questions? Okay, well then join me in thanking our panelists. Thank you very much for being here today. And so we are obviously happily inviting you for a drink just after this panel. And if you cannot stay, make sure to join us on Thursday evening, where we're hosting the best party of Paris Arbitration Week. So please make sure to come, and we'll be happy to have you again. Big thanks to our panelists, and thanks to you for joining us today at Jus Mundi. Thank you very much.